Greetings and welcome to Informal Logic, Appeals to Emotion, Understanding Persuasion Beyond Pure Reason. And we might have some musical entertainment after this at the Audit Them channel. Let's get right down to it. Before we begin, just to remind everyone this is strictly for the entertainment, educational purposes of this YouTube broadcast, not to be used misconstrued for anything legal, lawful, personal, private, business, tax, financial, or otherwise, so please don't do this at home. That said, let's get down to it. So, appeals to emotion in argumentation. How emotional reasoning influences persuasion and proof. Emotional appeals shape nearly every form of persuasion, from political oratory to jury advocacy. Interesting here. So we're thinking about appeals to emotion as a fallacy, yet they shape nearly every form of persuasion. Understanding these appeals equips jurists and advocates to separate persuasion that enlightens from persuasion that deceives. Fine distinction. The goal is not to banish emotion from reasoned dialogue, but to integrate it ethically within sound argumentation. So we're really splitting hairs here. The role of emotion in reasoning. And this is a quote from the text. This is from Douglas Walton's book on informal logic, and he is a preeminent scholar in the field of argumentation and informal logic. And his writings, to me, have been some of the best rounded. And being Canadian, he brings in that kind of North American approach, but not strictly United States of American approach. So it gives a better worldview to in the way these types of argumentation elements are integrated throughout the world. So let's continue. From the book, traditionally, appeals to emotion in argument have been distrusted and even labeled as logical fallacies. Yet some decisions to act on an emotional reaction, like fear, can turn out to be sound and justified. Conclusions which have survival value. Moreover, practical skill and experience may express themselves in what we call emotion or instinct. Wow, so practical skill and experience may be the things expressing themselves in what we call emotion or instinct. So another fine distinction, is it practical skill? Is it experience, right? Or is it emotion and instinct? So emotional reactions often encode experience and moral judgment rather than mere impulse. So we see an aggregation of experiences and moral judgment in emotional reactions. So two things, your previous experiences and your morals, your moral judgments. Those are what the emotions consist of. Logical training must discern when emotion signals genuine insight and when it distracts from proof. So is there a connection between experiences and moral judgment in the reaction? So in advocacy, emotion clarifies justice only when grounded in evidence and relative principles. So here in advocacy, the emotion clarifies justice, but only when it's grounded in evidence and relevant principles. So facts and conclusions of law, and then the emotion can clarify that, dismissing all emotion as fallacious overlooks the humane dimension of legal persuasion. So we can't dismiss all emotion as fallacious. By doing so, it's overlooking the humane dimension of legal persuasion. So we're on to the framework of emotional appeals. One problem with emotional appeals is that they tend to be inherently weak but plausible arguments. And if stronger and more objective arguments are also available, the problem is not to overlook them and to be seduced by the more attractive pull of personal emotions and interests. Once again, what he's saying here is the problem is not to overlook them and be seduced by the more attractive pull of emotions and interest. So the weak but plausible arguments that if stronger and more objective are available, then the problem is not to overlook them, is to not overlook them, to not overlook the objective arguments. So again, a lot of this has been compiled from his book because as a preeminent scholar, it wouldn't quite fit the whole presentation. But some of these here that give the framework, I had to bring in his exact quotes. And here we break it down. The emotional appeals possess surface plausibility that can mask evidentiary gaps. So the explaining the why through emotional appeals has a surface plausibility. The practitioner's task is to test whether emotion strengthens or supplants reasoning. So here's again, this is a common theme we'll see repeated, whether the emotion strengthens or supplants the reasoning. When feeling diverts inquiry or conceals missing proof, a fallacy of relevance occurs. So the fallacy is relevance. Three major forms will be examined: the ad populum, to the people, the ad baculum, to force, and the ad misericordiam, to pity. So, argumentum ad populum, the nature of the ad populum appeal. The ad populum, to the people, fallacy is traditionally characterized as the use of appeal to mass enthusiasms or popular sentiments in order to win assent for the conclusion of an argument not supported by good evidence. Ad populum succeeds by aligning the audience with majority feeling instead of factual support. It manipulates the comfort of conformity and the anxiety of exclusion. Look at that one there. It manipulates the comfort of conformity and the anxiety of exclusion. Agreement feels virtuous because it mirrors group identity, not because it rests on valid inference. In law, it appears when counsel invokes community outrage or patriotism to sway judgment, absent evidentiary foundation. Example, the insurance commercial. A life insurance advertisement depicts a joyful family picnic promising peace of mind today and security of the future, yet offering no policy terms or rates. The scene appeals to sentiment, trust, safety, family, while omitting material facts. The viewer's belief is guided by emotion rather than informed comparison. The emotional message substitutes for proof, constituting irrelevance rather than support. In advocacy, similar tactics occur when pathos replaces statutory or evidentiary grounding. The central test: does emotional appeal clarify value or obscure obligation to prove? Key question needs to be asked every time there's an emotional appeal to find out if it is a valid use or not, or if it's used to deceive. Context and burden of proof. If there is no burden of objective proof, there may be no fallacy of irrelevance. The issue comes down to the question of whether there ought to be a reasonable burden of proof on the arguer to supply information over and above emotional appeals. In other words, the problem is not emotion itself, but the failure to meet a rational standard of justification. So the standard of justification not the emotion itself, is the standard. The legitimacy of emotional persuasion depends on context and communicative duty. Commercial or political speech may use emotion permissibly to attract attention. Of course, this kind of thing here is part of what was introduced, I guess, with the law merchant and the traveling, the merchant fairs, because in a lot of areas it's not customary to use emotional persuasiveness to attract business. So that's kind of a custom that seems like now it's been adopted as a custom to allow this type of persuasive emotional speech to attract attention. But for legal advocates, the professional duty to reason and disclose evidence transforms omission into distortion. Key point here. So if the evidence includes emotional appeals, then it may be important to include it if you're aware of it and cognizant. Otherwise, it may be construed as an omission or a distortion by omission. So if there is an emotional context, the proper argument lets emotion accompany reason, but never replace it. Emotion may open the mind, but only evidence should close it. The argument from popularity, the definition and core form. One basic argument implicit in many ad populum appeals is that popular belief does not establish truth. The form everybody accepts A, therefore A is true, and nobody accepts A, therefore A is false, are not deductively valid. Argument from popularity equates consensus with correctness, mistaking social fact for logical warrant. It gains plausibility from human reliance on communal judgment. The error arises when collective belief is treated as conclusive rather than provisional. This reminds me of something, but I can't quite remember when or what it was. In jurisprudence, majority sentiment may guide legislation, but cannot define legal truth or constitutional meaning. Here's an example: the farmer politician. A politician with a PhD in economics claims, "We farmers must stand together," posing as one of the group to secure sympathy. The appeal constructs false solidarity by exploiting identity rather than presenting policy reasoning. Its persuasiveness depends on emotional trust, not logical coherence. The defect lies in substituting persona for premise. And for advocates, this warns against assuming moral authority through identification instead of argument. That's a good one there. Warning against assuming moral authority through identification instead of argument. Then there's a practical evaluation. The forms everybody accepts A, therefore A is true, and nobody accepts A, therefore A is false, are not deductively valid. Although these forms are weak, they can reasonably shift the burden of proof in dialogue. If one defends a conclusion that everyone rejects, stronger justification is required. So popularity may influence the burden of persuasion without determining the truth. Acting on consensus can be pragmatic when facts are uncertain, yet remains epistemically fragile. So, what we're saying here, acting on the consensus can be pragmatic when facts are uncertain. So, working on the consensus It makes it a lot easier because you can never ascertain the facts, but it remains epistemically fragile. So what this means epistemically means on the meaning. How do we know what the meaning is, the knowledge of this consensus here? We really don't, because the facts are uncertain. So when we look at if we're trying to make a judgment based on a practical evaluation of popularity, then you really can't build up a logical, reasonable way of explaining it in the way that relates to the material facts. Sound legal reasoning acknowledges custom or precedent as starting points, not as self-validating truths. So, of course, the customs or the precedents are a starting point, but they're not self-validating. So there's always exceptions. The advocate distinguishes persuasive likelihood from logical necessity. And we could always see here, this is like the stoplight at 3 in the morning when there's no other cars around. There's a certain custom, and that custom is a starting point, but it doesn't make it the truth. That going through that red light at 3 in the morning when there's not a car in sight wouldn't be, that's not the intent of the red light. The advocate distinguishes, or the custom, I should say. The advocate distinguishes persuasive likelihood from logical necessity. So this is the important thing, to distinguish a persuasive likelihood from a logical necessity. So again, acting on consensus can be pragmatic when facts are uncertain, but it's epistemically fragile. Problems with appeals to popularity, the peer pressure, and custom. Peer pressure. Operating on the basis of what the majority want or do is common, but when used to persuade another to act similarly, it often contains an element of peer pressure. Appeals to custom imply that conformity equals correctness. Such reasoning confuses descriptive behavior with prescriptive rightness. In law, social norms inform interpretation, but do not substitute for principle or justice. We have social norms that are used to interpret, but do not substitute principles or justice. The mature advocate questions whether the prevailing practice deserves continuation. So there it is, peer pressure and custom. Here's an example, the death penalty debate. If we reinstate capital punishment, we will stand with uncivilized nations. All modern democracies have abolished it. Now, the argument borrows prestige from majority practice, implying moral authority through numbers. Its weakness lies in assuming others' choices are automatically correct. Even accurate statistics cannot replace analysis of principle or consequence. And for jurists, this underscores that comparative law informs but never dictates domestic reasoning. So this is one of those sticky debate topics here. Nevertheless, you can see here where we use it to illustrate the weaknesses and the strengths in applying that emotional appeal here. Again, saying that the democracy or the large group implies a moral authority, but that implication is only done through numbers and without taking the extra step of doing an analysis of principles or consequence. So again, this takes us back to the previous slide here, or it was the one before this. Indeed, it was this one here. it's a little slow getting there. Come on, there we go. Yes, here we go. Yeah, starting points, not self-validating truths. Informs but never dictates. So you see the common themes we are weaving here. Then we have the rhetoric of belonging. The ad populum message cuts off reasonable dialogue. Those who agree belong. Those who question are outsiders. You're either with us or you're against us. It appeals to solidarity. And these appeals to solidarity can silence dissent by defining disagreement as disloyalty. This rhetoric of belonging converts deliberation into identity affirmation. In courtroom or political advocacy, such framing threatens impartial evaluation. Rational dialogue requires inclusion of opposing views without moral exclusion. See a lot of this. Oh boy, now we get on to the ad baculum, the threats and force. I think this means like with the club. Definition in essence. The ad baculum fallacy is resort to force or the threat of force to make someone accept a conclusion. In reasonable dialogue, such threats close off the freedom to decide on the basis of reason. The ad baculum replaces persuasion with coercion. The threat eliminates voluntary judgment, undermining rational autonomy. In legal context, intimidation of witnesses, jurors, or parties corrupt the deliberative process. And true argument invites assent. Coercion compels submission. Good sum up here. True argument invites assent, but coercion compels submission. Seems like we got a real low turnout here tonight, so please hit the like so maybe a notification will get out late for those that didn't get it. Here's an example, the Nazi newspaper notice. Here it is from the Nazi newspaper back at around the Second World War. The actual quote, "Our paper certainly deserves the support of every German. We shall continue to forward copies of it to you, and hope that you will not want to expose yourself to unfortunate consequences in the case of cancellation." The appeal employs fear to enforce conformity, rather than to present reasons. It leaves no space for rebuttal or discussion. Contrast this with lawful deterrence. Example given, penalties for drunk driving, which remains open to justification and review. The distinction lies in whether dialogue remains possible and reasons can be examined. See that? That's another common one we see today. It sure be a shame. All right, then we have warning versus threat. Whether something is a threat or a warning depends on how it is taken. A warning may inform. A threat intimidates. So we look at how it's taken up, what is said. The context determines whether an appeal to fear is legitimate or coercive. A warning aims to protect by conveying risk. A threat aims to control by creating fear. Legal analysis requires examining intent, capacity, and credibility of the actor. 3 good points: intent, capacity, and credibility. Ethical advocacy warns of lawful consequences, but never implies personal harm or reprisal. Really, ethical advocacy warns of lawful consequences, but never implies personal harm or reprisal. You don't say. The fear appeal scheme. If you do not bring about A, then D will occur. D is a very bad outcome. Therefore, you should bring about A. Fear appeals can be reasonable when they alert to genuine harm. The fallacy arises when fear is fabricated or disproportionate to evidence. Public safety campaigns use this form ethically. Demagogues use it manipulatively. The legal advocate must ensure that consequence-based argument rests on fact, not intimidation. Further ad baculum problems: emotional and instinctive reasoning. The prisoner who confesses under threat may not be illogical. He responds to a different kind of reasoning that places survival above truth. So not all fear-based actions are irrational. Some express pragmatic reasoning. Yet, when such reasoning enters dialogue, it invalidates the fairness of the process. In legal ethics, obtaining assent through fear voids voluntariness and due process. Understanding this distinction sharpens recognition of coercive fallacies. So this is an important thing here too, is that the distinction sharpens a recognition of the coercive fallacy. So this is the thing here, the fairness and legal ethic, obtaining assent through fear voids of voluntariness. It's a different kind of reasoning here that goes on. It's not really to the material case, it's to a survival instinct. So this is another aspect of recognizing how these coercive fallacies might manifest themselves. Here's an example of the jury intimidation. A terrorist defendant asked about jurors' security, implying retribution. Jurors failed to appear, and the trial was delayed. Perfect plan. A terrorist defendant asked about juror security, implying retribution. The jurors failed to appear. Even indirect threats can halt deliberation by instilling fear. The tactic prevents rational adjudication and violates the norms of dialogue. Such interference transforms argument into domination, rendering any verdict meaningless. The episode exemplifies how ad baculum undermines justice itself. So look how subtle it could be. A terrorist defendant asked about job security, implying retribution. Nice. Negotiation and legitimacy. The use of a threat can be reasonable in negotiation dialogue, but fallacious in persuasion dialogue, where the aim is to resolve opinion by reasons. Okay, so negotiations, it's okay to use a threat, but not in persuasions. The context determines propriety. Negotiation may tolerate leverage. Adjudication may not. Threats as bargaining tools differ from threats as proofs. Confusion arises when a dialogue shifts from persuasion to negotiation mid-exchange. Wow, we've seen this a lot, huh? The disciplined advocate keeps reasoning forms distinct and transparent. So the reasoning form is always kept transparent and distinct from the negotiation form. Ad misericordiam. Misericordium. Ad misericordium. I think that's how you say it. The appeal to pity. Definition and principle. What can be fallacious about the appeal to pity is the same error that we found in relation to the two previous types of emotional appeal. The emotional appeal can be used as a distraction from relevant evidence that should be brought forward to argue for a conclusion. It is a variant of ignoratio elenchi, where the distraction is pity. The ad misericordiam seeks assent through compassion rather than demonstration. The fallacy occurs when sympathy eclipses the issue to be proved. Yet compassion may be relevant when justice itself requires equitable consideration. So there is the appeal to pity when justice itself requires equitable consideration. The challenge for advocates is discerning when mercy informs fairness and when it obstructs it. And we're on to an example here, the defense attorney's plea. Counsel urges acquittal because the accused is poor and emotionally scarred, portraying him as a victim of circumstance. The plea redirects judgment from guilty to sympathy. Pity may justify leniency in sentencing, but not exoneration from liability. Allowing emotion to define culpability confuses moral sympathy with evidentiary relevance. Judicial integrity demands that empathy guide equity without distorting fact-finding. In a perfect world. Example, the late essay. A student begs acceptance of a late paper due to personal misfortunes and travel plans. The request appeals to mercy at the expense of fairness to others. The professor, like a judge, must balance compassion with procedural equality. The analogy illustrates that rules exist to protect fairness, not to suppress kindness. So, the rules exist to protect fairness, not to suppress kindness. Emotion informs discretion only within boundaries of consistency and proof. So we see here kindness is a generative gesture, whereas to protect fairness, not to suppress kindness. So fairness here has to be protected, yet kindness should be given out without any suppression. The emotion informs discretion, only within the bounds of consistency, though, and proof. So it can't be on just a feeling. The overt and pictorial appeals to pity. Here's one example, the Ethiopian famine appeal. A full-page advertisement shows a starving child and urges, "Your gift of $15 will feed a hungry child for a month." The emotional appeal leaps from the photograph, yet the response it invites is appropriate and humane. So, not all emotional appeals are fallacious. Some rest on verified urgency and moral duty. Here, pity aligns with evidence of real suffering and actionable remedy. Emotion justifies response when it directs attention to genuine fact rather than sentimental illusion. And ethical persuasion joins compassion with credible information. And I'm sure all 20% of your donations will go there. All right, evaluating pictorial and visual appeals. So we got to evaluate these pictorial and visual appeals. Picture of the starving kid. Even in legitimate appeals, we must specify what the conclusion is and whether the proposed action follows from the evidence rather than a feeling. The viewer must discern whether emotional imagery advances reasoned choice or manipulates impulse. In legal advocacy, demonstrative evidence should inform understanding, not provoke bias. Here's a standard test. Would the argument stand if emotion were removed? So there it is. If you took the picture of the kid away, would the would the argument still stand? True persuasion survives rational scrutiny. Manipulation collapses without it. There it is. With a scrutiny, rational scrutiny, manipulation collapses. So true persuasion survives the rational scrutiny, but manipulation collapses. Synthesis and application. Here's a comparative review. We have the appeal, which emotion it appeals to, the risk, and legitimate use. So the legitimate use is where these, as we said, it's a fine line with emotional appeals. They're not all necessarily fallacies, just some are a variant of other fallacies. So let's look at where the legitimate use is and then the risk of where they might coincide with another fallacy. So, starting with the appeal, the ad populum. The emotion, you want to be belonging. Remember, this is to the masses. The risk is conformity over reason, wanting to belong. But the legitimate use is building rapport or context. So this might be legitimate use in commercial use, political use. Ad baculum, the emotion it evokes is fear. The risk is that when it's used for coercion, but the legitimate use is lawful deterrence or warning. So bad penalties if you run that red light. Then there's the ad misericordium. That's pity is the emotion. Appeal to pity. The risk is a distraction from evidence. Remember, it can help with the evidence, opening the mind to it, but the mind's closed by the evidence itself. The legitimate use, though, is sentencing or equity consideration. So those pities to mercy can be used in certain circumstances legitimately. As I said, it's a fine line of discernment when it comes to appeals to emotion. Identifying fallacious use. The hallmark of a fallacy is irrelevance. Emotion standing where proof belongs. Ask whether the appeal shifts focus from reasoning to reaction. Evaluate the communicator's burden of proof and context of duty. When an emotion blocks inquiry or silences opposition, dialogue ceases to be rational. So here's great ways to identify when they're being misused, the appeals to emotion. And then there's the ethical and legal application of these. Advocacy inevitably involves emotion. Ethical advocacy disciplines it. Emotion is valid when tied to facts, proportional to context, and transparent in motive. The jurist's task is not emotional detachment, but emotional integrity, feeling guided by reason. Justice requires both heart and logic, harmonized through awareness of fallacy. And for our closing reflection, emotion is not the enemy of reason, but its companion. The fallacy lies not in feeling, but in misusing feeling to obscure truth. Effective reasoning honors both intellect and empathy. The disciplined advocate integrates logic, credibility, and humanity. Emotional literacy and argumentation safeguards due process and persuasive integrity. Mastery of informal logic ensures that passion serves justice, never subverts it. And that takes us to the end of the presentation of informal logic, the appeals to emotion, understanding the persuasion beyond pure reason. So we learned about the ethical implications and the pitfalls of the fallacies. And again, the ignoratio elenchi being the ignoring the issue at hand is an easy way of misusing appeals to emotion to distract. So this is one way you'll see them used in that fallacy. The appeals themselves are not the fallacy, it's the way they are used. And I think that's the biggest takeaway. With that said, I'd like to thank you all for coming in and participating in this, and I hope to see you all on the next one. Peace out.